Can a domestic violence victim drop charges in Illinois? This is a very common question that people ask. The answer is not directly. A domestic violence case is a criminal case between the government and the defendant, not between the victim and the defendant. But a victim can often cause a domestic violence case to be dismissed by following this 5-step process. Step 1. Change the conditions of bond to permit contact. When a person is arrested for domestic violence, that person is taken before a judge who sets bond conditions. The judge orders that the defendant is to have no contact with the victim. In every case, the defendant is not to contact the victim for 72 hours. In many cases, the judge goes beyond the mandatory 72 hours and orders that the defendant have no contact with the victim until the case is resolved. This can be a very big problem because the case often lasts several months. For that time, the defendant and the victim, who may be husband and wife or boyfriend and girlfriend, may be forced to live in separate residences, which they cannot afford. Many relationships will fall apart in the time that they are forced to be apart. A domestic battery victim who wants to drop charges should immediately call the defendant's lawyer to coordinate changing the bond conditions so that they can have contact. If the defendant has not yet hired a lawyer, the victim should call a good domestic violence defense lawyer herself in order to get the process started. It is important to point out that the victim has a perfect right to communicate with the defendant's lawyer. The victim and the defendant do not need to wait until the first court date, which may be as long as a month away, in order to change the bond conditions to permit contact. A domestic battery defense lawyer will be able to appear in court almost immediately in order to ask the judge to permit contact. Allowing contact between the victim and the defendant is important if the two of them want to continue their relationship. It is also important to be able to coordinate with the defense if the victim wants to drop domestic battery charges against her husband or boyfriend. Step 2. Have the lawyer negotiate for a dismissal. The defendant's attorney can often approach the prosecutor and negotiate to have the charges dismissed. Things that a prosecutor may consider in deciding whether to dismiss a domestic violence case or not include whether the victim is cooperating with the defense or with the prosecution, the seriousness of the injuries, the defendant's background, and whether there is a history of abuse, and the skill of the defense lawyer being incapable of blocking other forms of evidence from coming in at trial if the victim does not testify. Step 3. Pre-trial dismissal. In cases where the prosecutor is not willing to dismiss charges, the defense lawyer sets the case for trial. Very often, the case may be dismissed on the day of trial. Step 4. Pre-trial legal maneuvering. In a number of cases, the victim may also be charged or be in danger of being charged with a crime. In these circumstances, the victim may assert her Fifth Amendment rights against self-incrimination. This often results in the domestic violence charges being dismissed. Step 5. Testimony at trial. If a case is not dismissed prior to this point, the victim can cooperate with the defense attorney and testify truthfully and put into context for the court to understand what really happened. This often results in a finding of not guilty. There are a number of very common misconceptions about a victim dropping domestic violence charges. 4 very common misconceptions are the following. Misconception 1. A victim can just drop the charges by calling the police or the prosecutor. This almost never works. The police already decided to file charges, often against the victim's wishes. They will not just dismiss the case because the victim makes a phone call or because she changes her mind. Common misconception 2 is that a victim can drop the charges by writing a letter to the prosecutor. This also will not work. It may even backfire. At a trial, the prosecutor might try and use the letter against the victim. Common misconception 3 is that a victim can drop the charges by not showing up to court. This is probably the most common misconception in domestic violence law. The reality is that the government will often subpoena the victim, ask for a continuance if she does not appear, or even try and prove the case without the victim's testimony. Common misconception 4 is that a victim can drop the charges by recanting her statement. If she tries to do this, the prosecutor will often confront her with the statements that she made to the police, including written statements and statements on video recordings. Our law firm has defended hundreds of domestic violence cases. We have gotten the majority of those cases completely dismissed. Please call or email us for a free legal consultation. This video is for informational purposes only and is not legal advice. No attorney-client relationship is created and viewers may not rely on this video in any way. We are happy to speak with you on the phone and provide legal advice. Please call or email us for a free legal consultation. We are available 24 hours a day.